Shalom, brothers and sisters. This is your brother Wasilkamilbey, and this is Shamstoppers on this Saturday. And the title of this video is called "Stop Trying to Modify Her Debt." Don't modify her debt. We're going to talk about what modifications mean. And we're going to get on false, deceptive practices by these liars. You know what I'm saying? Come to my good book. See what modification means? Modifications or changes in the contract may be provided for at the time of making the contract by a condition which shall have that effect. There go the example. Let me get to the bottom. A contract may be modified by the consent of both parties after it has been made. Huh? The reason why you fools get railroaded because y'all didn't sit down and make that contract. So you can ask for a modification all you want to. You ain't gonna get it. Because it ain't your contract, it's hers. It's her fucking debt. It's her fucking bill. Stop being pussies. We dropping this knowledge on you. You know what I'm saying? Now we're gonna get on his ass. Alright? This motherfucker's in Florida. You see this shit? You see this shit? Legal advertising. You ready for this? Misleading, what they say, false, misleading, or deceptive statements, prohibition. See that? Advertisement shall contain any false, misleading, or deceptive statement or omit to the state any fact necessary to make the statements made in light of the circumstances under which they are made, not false, misleading, or deceptive. Now, let's listen to this shit.
Hi, my name is Mark Joseph, and I'm a South Florida family law attorney. And these are 5 things you should know about modifying a final judgment. In family law, when you get a final judgment, whether it be a divorce, paternity action, or child support, you can, under certain circumstances, have that judgment modified.
Did you hear what he just said? You can. He didn't say you will.
Modify an agreement. You're saying that there is a substantial material change in circumstances that requires the court to change the order from what it was at the time you signed it to whatever the new circumstances are. This can include changes to pretty much any term in the final judgment, which includes parental responsibility, time sharing if it involves children, child support, alimony, or anything else that the final judgment addresses. However, you cannot do this just by saying you don't like the terms of the agreement.
Did you just hear that? Rewind this video, go back to what I read, y'all.
Has to be a substantial material change in circumstances, which was unanticipated when the original judgment was entered. What I mean by that is something has happened that wasn't considered in the final judgment after the final judgment. A classic example of this is when the court addresses child support and they base a party's income on, let's say, $5,000 a month, and they lose their job, or they get a new job and they're making less money. Depending on the amount of money that they now make, they may qualify for modification. And it can happen in the inverse if the person starts making more money. Another example of this is in regards to time sharing. If you already have a particular schedule with the child or children, there might be circumstances that may change that may allow you to have less time or more time. If you do this unilaterally, you would likely be found in contempt of court.
Now, what fucking reasons is he giving? Bullshit. It's not your contract, fools. It's the bitch contract, and they making money off the bitch. And then you the bitchette falling for the shit.
However, you can go back to court and request this modification to have the court order consider these new factors. It is not automatic. Just because you think it's a substantial change that's material and was unanticipated, that doesn't mean the court will agree. Also, even if the court agrees, there is a final factor that needs to be considered: the best interest of the child or children.
So he used that word interest. Okay, he got all these law books around here. Motherfucker ain't read not one of them. He playing on y'all like he know what the fuck he talking about. And some of you, I'm gonna talk about you dumbass motherfuckers who want people to speak so articulate and say big words and all this old shit. You know what I'm saying? You keep being a goddamn fool, you big dumb bitch. Keep falling for the shit. Now I'm telling you, the people that come over here, they 30 steps ahead. Because these dudes right here, he's a professional. So what that means, he's a professional. So he's practicing on your stupid ass. And he ain't supposed to be advertising this shit anyway.
Make sure it's valid. A modification or a supplemental petition to modify a final judgment is essentially another case. You're choosing to reopen your case, reevaluate the evidence, and go through the entire court process again. If you're going to do that, you need to be sure that the reasons why you're doing this is something that can hold up in court. That being said, I strongly suggest you consult an attorney if you are intending on modifying a final judgment.
Why he want you to consult an attorney? Why? Because his attorney's his homeboy. And what is it, Miami-Dade? This nigga running around here? Ask this nigga, can you get off of child support? If George Zimmerman, OJ can kill a motherfucker, ask him why you can't get off of child support. Nigga, fuck family law. That ain't no real law anyway. They ain't gonna get rid of this old bullshit. Told y'all niggas, what's y'all law? Huh? What's your fucking law? Being a bitch and a simp. Hit us up, peace.